Good morning, Dan Citron. So we are going to start to see Daubert hearings on everything in personal injury cases that normally just came in through a medical doctor's pure opinion. And the committee notes, I believe it is, mandate that we follow the federal court system. So pure opinion is full game here. And so that means that whether somebody has sustained a neck injury, whether somebody has a permanent injury within a reasonable degree of medical probability, whether somebody has sustained an aggravation of a pre-existing injury, the medical bills that a person will incur in the future, each one of these items will become the subject of a Daubert hearing in every case.
It's not before us, but what if we were to pass a rule? Let's just, again, as Justice Lewis says, Daubert right now is a statute. Fry was the case law. But what you're talking about is an abuse of the process. It happens in discovery all the time. Why hasn't anyone proposed in these 2 years rules that say that somebody could be sanctioned for bringing a frivolous Daubert motion when it clearly doesn't apply to things that what you say, the ordinary automobile accident? Because again, you've got criminal defendants that say they will benefit from Daubert because the state tries to put in science or science that is not reliable. And now you want an across-the-board ruling. Has anyone looked at that about trying to rein in the procedures for how Daubert hearings are conducted?
Daubert is devastating to across the board to these small cases with basic pure opinion, and pure opinion applies in federal court. Every one of these things that I mentioned are subject in federal court and in many states that have adopted Daubert to Daubert testing. So Daubert not only affects this small case, but it puts the situation where we cannot take cases worth hundreds of thousands of dollars. We can no longer take some of these cases. And as far as criminal is concerned, every law review article shows that where the prosecution's witnesses are challenged, the criminal defendant is virtually never successful. On the other hand, the success rate where the prosecution challenges the criminal defendant's expert, they are successful about twice as much if you read all of these law review articles. So it's not just in this pure opinion, and there's nothing in any federal court that's ever sanctioned anybody for bringing any type of challenge to a pure opinion test. For example, if something fell off something in Walmart, fell on somebody's head, and somebody came in as to the maintenance procedures as to how to put something on a shelf, that's subject to a Daubert hearing. So a manager of a store who normally would just come in and say, here's the procedures, that's fair game for Daubert, and that's pretty much pure opinion. Rule 1.010 of the Florida Rules of Civil Procedure provides that these rules shall ensure the just, speedy, and inexpensive determination of every action. Daubert is going to ensure that we have the unjust, slow, and excruciatingly expensive determination of every action. Our courts are not equipped like the federal courts. We don't have our trial judges do not have two law clerks who can sit there and in every case plow out 2, 3, 5, 20, 40-page opinions of each expert. That is 30, I was practicing 32 years by the time Daubert was adopted. I have never had a Daubert hearing, a Fry hearing in my life. It never came up. And now we have all these things set, and it is going to add probably to the average personal injury case, probably 40%, more in time, 40% more in costs. Thank you very much.